Excited. Please be seated.
The defendants in the courtroom. Ladies and gentlemen, the jury has knocked on their door and announced that they have a verdict. Before I bring them in, I want to remind everyone of the conduct requirements, although I really think this is not necessary with this group. But remember, the jury is entitled to their verdict, and it is entitled to respect, and there's oftentimes people that have opinions and thoughts about them and verdicts, and if you find yourself to be perhaps that person that may not be comfortable with a verdict that they find contrary to their point of view, then it would be appropriate to step out and not be in the courtroom, because I won't allow anyone to express any opinions of the work that the jury has done. They've been studious, they've been dedicated, they've worked very, very hard, and the taking on of this responsibility as a citizen is certainly nothing that anyone volunteers for. When you're pulled out of your private life and serve on a jury, then that work, when they've worked so hard, is deserving of great respect. And I know that everyone in this courtroom feels the same way and will adhere to those conduct requirements. With that, please bring in the jury.
Let's all rise for the jury, please. Please watch yourself. Please watch yourself. That's fine. Please be seated.
Members of the jury, it's good to see you again. My understanding is that the jury has arrived at a verdict. Would the foreperson please stand? Ms. Graham, is that correct? Have you in fact arrived at a verdict?
Yes, sir.
If you will hand it to the bailiff will bring the verdict to me for my review. The verdict is in proper form to be received by the court. At this time, I'm going to ask the clerk to publish the verdict. Thank you, Mr. Phillips.
In the Superior Court, County, State of Georgia versus Justin Ross Harris, defendant, case number 14-9-0101, 3124 verdict form. We, the jury, find as follows: count 1, malice murder. As to count 1, we find the defendant guilty this 14th day of November 2016. Kill only 4 persons. Count 2, felony murder. As to count 2, we find the defendant guilty this 14th day of November 2014. Kill only 4 persons. Count 3, felony murder. As to count 3, found the defendant guilty this 14th day of November 2016. CN, 4 person. Count 4, cruelty to children in the first degree. As to count 4, we found the defendant guilty this 14th day of November 2016. CN, 4 person. Count 5, cruelty to children in the second degree. As to count 5, we found the defendant guilty this 14th day of November 2016. CN, 4 person. Count 6, criminal intent to commit a felony, to wit, sexual exploitation of children. As to count 6, we found the defendant guilty this 14th day of November 2016. CN, 4 person. Count 7, dissemination of harmful materials to minors. As to count 7, we found the defendant guilty this 14th day of November 2016. CN, 4 person. Count 8, dissemination of harmful materials to minors. As to count 8, we found the defendant guilty this 14th day of November 2016. CN, 4 person.
Counsel approach to review the verdict. Does the state have further of the jury?
No, Your Honor.
Does the defense?
We'll ask for a comment.
Certainly. Ladies and gentlemen, we've received your verdict and it's been published in open court. The next step in the trial is the poll of the jury. The poll of the jury is when you're called upon to confirm that the verdict that has been rendered by the jury is in fact your verdict. The way I'll do that is the clerk will call your names by initials shortly. When your initials are called, please stand and I will ask you 3 questions. I'll ask you if you heard the verdict as it was read in open court, and then you would answer whatever your answer may be. The next thing I would ask is if the, then I will ask you if the verdict that you heard is in fact the verdict that you had in your jury room. Then I'll ask you if in fact the verdict that you heard is the verdict of all the jurors in the jury room. And finally, I will ask you if the verdict is still your verdict. And then, as you know, you're under oath. To all of those 4 questions, you would answer truthfully as the case might be as to what your answer would be. And with that, I'll ask Mr. Phillips to go and begin to call the roll of the jurors.
J.G.
Please stand. Did you hear the verdict as it was read in open court?
Yes, I have.
Was that your verdict in the jury room?
Yes, it was.
Was it the verdict of your fellow jurors?
Yes, ma'am.
And is it still your verdict?
Yes, it is.
Thank you. Please be seated.
C.P.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was we got it. Eventually we'll be there. Yes, sir. Did you hear the verdict as it was read in open court? Was that your verdict in the jury room? Was it the verdict of your fellow jurors? Is it still your verdict? Thank you. Please stand.
C.P.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, it was.
Is it still your verdict?
Yes, ma'am.
Please be seated.
S.M.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors? Is it still your verdict?
N.H.
Did you hear the verdict as it was read in open court?
Yes, Your Honor.
Was that your verdict in the jury room?
Yes, it was.
Is it still your verdict?
Yes, ma'am.
And was it the verdict of your fellow jurors?
Yes, yeah.
Thank you so much.
P, E,
Did you hear the verdict as it was read in open court?
Yes.
Was that the verdict of, was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Thank you.
P, O,
Did you hear the verdict as read in open court? Was that your verdict in the jury room? Was it the verdict of your fellow jurors? And is it still your verdict?
Yes.
Thank you.
J, J,
Did you hear the verdict as it was?
two J, J. This is a male.
Did you hear the verdict as it was read in open court? Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors? Is it still your verdict?
J, R,
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict?
It is.
Thank you.
G, G.
Did you hear the verdict as read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am. J, J.
Did you hear the verdict as read in open court?
Yes, I did.
Was it your verdict in the jury room?
Yes, it was.
Was it the verdict of your fellow jurors?
Yes, it was.
Is it still your verdict?
Yes, it is.
K, N.
Did you hear the verdict as read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Anything further from the state?
No, Your Honor.
Anything further from the defense?
Not as far as the jury's concerned, Judge.
We'll take up issues in a moment. We're going to give the verdict to the clerk. Ladies and gentlemen, that concludes your service on this case. So, what are next steps? Well, I'll be discharging you shortly, but I'd like you to know about the next steps in the case. As you remember that I told you in the charge of the court, I explained to you that sentencing was not an issue in your jury deliberations. And that's because we have a bifurcated system of jury trials, and by means two, as you know. So the first step is the determination of guilt or innocence. You can't even begin to contemplate or consider or evaluate appropriate punishment until you've determined if a person is guilty or not guilty. And that is a jury function. That's where people from the community are brought together to bring about their really common sense. The verdict of a jury is the sense, the common sense of the 12 jurors who come from all different walks of life, evaluating evidence, applying law to evidence, and letting that create a verdict. But you can't talk about punishment until a person has been found guilty. It doesn't make sense. In cases such as this, once a jury arrives at a verdict, and in this case a guilty verdict, then the responsibility of sentencing falls to the trial judge, and that's me. And what happens is called a sentencing hearing. And at a sentencing hearing, there can be evidence offered. And evidence would come to the court in one of two ways, in basically two natures. One is in the nature of aggravation, and the other is in the nature of mitigation. Aggravating evidence is evidence that would take you to, say you had a median sentence, that all things being equal, this would be the normal sentence in a case. Aggravating evidence would be that which takes you to a stronger social response. Punishment is a social response to behavior that's against the law. And if there's evidence that's offered, and it can be evidence from the trial, maybe nothing more than, and often is, that there's no more evidence other than what's been heard at the trial. So that could be aggravating evidence. But it could also be something like prior criminal convictions, other things of that nature that the law allows the sentencing judge to take into account in arriving at the appropriate punishment. The other type of evidence is mitigating evidence, and that which, if we're at the meeting point, takes you to a less harsh sentence. Youth is often considered to be mitigating. There can be evidence in the trial that amounts to mitigating evidence. Lack of a criminal record can be mitigating evidence. There's a hearing to accomplish that, and each side, the state, can offer evidence in aggravation. The defense can offer evidence in mitigation. And then, just as you saw in the trial, there's argument. Each side can state what they think is an appropriate sentence within the range that the law sets out, and argue to the court persuasively what's the appropriate sentence. I mentioned a feature that's important to keep in mind. I don't have unfettered decision-making, just like you did. You had law you had to follow based on evidence to arrive at a verdict. I have law I have to follow based on evidence in sentencing to arrive at a sentence. So what is the law specifically that I'm talking about? Each offense has sentences that are set forth by statute. The law that I told you about, when I define malice murder, when I define felony murder, when I define the cruelties to children and the dissemination counts, they all have ranges or specific punishments that go with that offense. And then there's some other nuanced aspects of how sentencing occurs. But after I discharge you, then I'll have to determine when the sentencing will occur. And I'll certainly want to share that information with you. You're a part of the case. I'm discharging you, and you're going to go back into your free lives, which you have not had for quite some time. And, for the rest of us, too, we haven't had our free lives either. We've been here in a very accommodating community. What's been here for us from Cobb County trying this case has been, hospitality's been remarkable. The support and help to us to do our task has been remarkable. And I hope for you that you find that to be true as well. I believe you probably do. It's just been very remarkable. And everyone involved should be commended. But to go back into your civic life and your civilian life, and yet I'm sure you would like to have the information so you can have access to being able to see and hear what happens in the sentencing. And I will be sure to get that to you so you will know. Why am I saying that? I don't know yet when we're going to do it. I need to listen to both sides. That's the next step after I discharge you, is to listen to the lawyers and talk about next steps as to when we get to sentencing. What type of preparation do they need? What is their time frame? Sometimes you try cases and you immediately have sentencing. Oftentimes you have to wait because there are witnesses that need to be summoned and brought into court. So there's still moving parts on my end, at their end as well. Before I discharge you, I'd like to say to you that you've seen, in my opinion, very good trial work. The lawyers have done an outstanding job in representing Mr. Harris and making sure that not only were his rights protected, and sometimes you get a little jaded about rights, but rights matter because they define us as a society. And if heaven forbid we ever find ourselves in a circumstance or a family in a circumstance, we want to make sure we live in a society where those rights protected to us are there for us. It's an equalizer. It makes us all equal under the law. And that's one of the hallmarks of American society. And you've seen very good lawyering in that regard. You've also seen very good development of the facts and circumstances. The presentation was very good, and I see lawyers all the time. I am one. I'm pleased to be one. I'm very proud of the career choices I've made that have given me such an ability to see how our system works, how justice works in our country and in Georgia. And you've seen very high quality work, and I commend the lawyers for that. Having said that, I'm going to excuse you. I'm going to send you back to your jury room. The poor alternates. Bless your hearts. You must have, I can't, every time I have to tell somebody they're an alternate, I go, this is as punishing to me as it is to them to say, yep, we made you sit here. Yep, we made you listen. And now we're going to put you in a room. And you're going to have to play whatever, do whatever y'all were doing. And the frustration, I'm very sensitive to it. We couldn't have tried the case without you. What if somebody got sick? You would not believe, I was washing my hands every minute thinking, I do not need the flu. I got my shot. I don't need to get sick. And I was thinking, and you all don't need to be sick. Nobody needs to get sick. But what if somebody had? You know it can happen. So we had to have the alternates for that purpose. You all have been a true pleasure to work with. You showed up on time. You've worked really hard. You've been attentive. All the things that I would say A++ jurors do, you all did. And I absolutely appreciate that very much. It's made it so much easier on all of us. Judges can't comment on verdicts, so if you think I'm going to or not, your function. You all have acquitted yourselves and worked hard and are greatly deserving of the hard work and attention, dedication that you've put to this. And I can say that is appreciated. So, I'm going to send you back to your jury room. I think there'll be probably some paperwork and follow-up. Traditionally, what is done is the lawyers and the judge come back just simply to answer any questions. And if you've got a minute for the lawyers and you're comfortable with it, please do that. I've been involved with juries my entire legal career. I used to try cases, and win, lose, or draw, I always appreciated talking to the jurors. It made me a better lawyer. It made me a better person, a stronger person, better able to see many facets and aspects of things that through my life I wouldn't know about, because I have my life. I don't have the benefit of other people's lives. But by talking and listening to other people, I found that I grew a lot and became much better as a lawyer, as a judge, and as a human being. On the other hand, you may have had plenty of us. And so now is the time to take your paperwork and say so long. And we're not going to rush it on top of y'all. Y'all need to think about it one another. There's got to be some de-escalation. There's got to be a moment to go and then shake hands and hug necks and say, I enjoyed breaking bread with you. I enjoyed knowing about your family. I enjoyed working with you. All those things that you all need to have a moment to do. And then once you've got your paperwork and y'all had your moments together with each other, I'll spend that time working with lawyers to figure out when we'll be doing sentencing. Then if you would like to leave, please do so. If you'd like to stay and have a chance to people that you've worked with so long to shake a hand or make a comment or share a thought, we'll step back with you for this one. So with those comments, I'm going to excuse you to your jury room. Y'all take your time to decompress. Yep. Yes. And Mr. Purdue, if you'll find out, I don't know if they need checks. I don't know. They're on their way. See, I am thinking.
I believe they are forthcoming.
I am thinking of your best interest, am I not? Whether you've noticed it or not, that's been a primary concern of mine. So if you'll step out, and we'll step back to see you in a moment and let you know.
All right, jury, please. Please watch yourself going down. Please be seated.
What I said to the jury, I sincerely mean, gentlemen, you all tried a really good case. You worked hard and it's been well developed. And I need to say that to you all as well. Sentencing hearing, what says the state?
State will be ready whenever, Your Honor. We do have to, I think, under the law, notify next of kin and victim and the latter counts of the indictment for when sentencing is going to be set, but we'll try to do that as soon as we can, as soon as Your Honor sets a date. We're ready whenever.
Defense?
We're ready now.
Well, they have to notify people. I don't see that as happening.
What are we doing first week of December?
Have you got the calendar?
That calendar call.
How long do you anticipate the sentencing hearing to be?
From the state's position, probably no more than 15, 20 minutes.
And from the defense, do you have an estimation?
We will be putting up no evidence nor making any argument.
Let's set for December the 5th at 1:30 in my courtroom in Cobb County. All right, we need to advise the defendant of his appellate rights. Mr. Kilgore, I don't anticipate you had an opportunity to discuss that with your client.
It's been discussed at great length.
Then to your credit, do you want to make a predicate statement of some sort?
I do not.
Well, then what have you advised him of?
That if he's convicted, he has the right to appeal, and we'll be taking care of that.
You're going to take care of that?
Yes, ma'am.
Okay, all right. Well, then, Mr. Harris, the counsel has advised me that y'all have discussed appellate issues at length, and that they are going to file the notices of appeal in a timely manner. Generally, that's going to be within 30 days, at least kind of a blanket notice of appeal to be fleshed out at a later time. Would that be consistent with what you advised to Mr.
That's,
Kilgore?
we went into a good bit more detail, but he's aware of those rights that he has, and he's aware that we're going to be handling those in the proper fashion, Judge.
Well, the thing that's important for me to tell Mr. Harris is that he's got 30 days to file a notice of appeal, and it can be very blanket and pro forma, but the 30 days is the deadline, and that's what needs to be set by the court. Mr. Harris, do you understand that?
Yes, ma'am.
All right, is there anything else for the state?
No, Your Honor.
Is there anything else for the defense?
Not at this time, Judge.
Do you want to step back and see the jury?
We would, Judge. I know we'd spoken about this earlier. It may not be the best idea, but just a thought we had, possibly, so they don't feel pressure. If they wanted to come back maybe in the morning to the courthouse for a meeting in a room or something like that, to meet at maybe 8:30, 9 o'clock, if they're open to that way. Just a thought.
I'm inclined to say, they'll say no, thank you.
But we would like a minute to speak with them if at all possible.
Well, y'all just stay put and I'll work it out to where it's going to be best for everybody.
Yes, ma'am.
How about the defense?
I think that at least one of us is probably going to want to speak to him.
Perfect. All right. Sheriff Jump, thank you so much for your officers and your outstanding hospitality.
Judge Frank, thank you.
Greatly appreciate it. All right, I'm going to take a recess now, and I'm going to get the jury settled and figure out what's the best place. They may want to come in here, but I don't know that they're going to want to. Ladies and gentlemen, the press may not be who they're interested in. I don't know. You know, at this point, they're free agents. Let's let them have some freedom and some input into what we do. So I will go and work on that. This court stands in recess. I hope you wait till tomorrow.
Please just stop the matter. She's good. You just got to go back. Yeah.